When will we know if the ban on non-competes in the US will actually take effect? Today we have an update. If you remember, a week ago, the FTC, the Federal Trade Commission, issued its final rule banning non-competes in the US, but it didn't take effect right away. It's not scheduled to actually be effective, the ban, until the end of August. But I made some videos about this. Even though it's called a final rule, it's not actually final, because business groups can challenge it in court from it actually taking effect. And that's happened. Now, I won't hide the ball. July 3rd may be a key date to know whether it will actually take effect in late August. Now, let me give you some context. I made a video about one lawsuit that was filed in Texas right after the rule came out. It was filed by the U.S. Chamber of Commerce, which I believe is the largest lobbying group in the U.S., basically advocates for businesses, and two other groups. And in this video, I talk about that case and how it's before a judge who is very conservative, a Trump-appointed judge, who has already struck down a number of agency rules, kind of like the FTC's rule, but different agency rules under President Biden's administration. So objectively, it doesn't look so good for the FTC in that. But another case that was also filed that I briefly talked about is the one that I'm going to talk about today. Now, Ryan LLC, who filed this suit, is a global tax advisory firm that's headquartered in Texas. So they filed this suit, and it basically says very similar things to the U.S. Chamber of Commerce's suit. Overall, that the FTC doesn't have legal authority to issue such a sweeping ban on non-competes, that this should be done by Congress as elected officials, and they haven't done it, so the FTC can't do this. And that's a really shortened version of arguments that take many, many pages. But so Ryan is filing this as a business. Now, what's notable is that Ryan LLC filed its own lawsuit in federal court in Texas, just like the Chamber of Commerce did, but Ryan LLC filed it first. And who pointed this out? The FTC. The FTC filed this motion with a very long title in the U.S. Chamber of Commerce's suit yesterday. But one notable thing it points out is that Ryan LLC filed first. So they're saying, hey, all the cases should be consolidated into that Ryan court, which is by another judge. What this means is like the race to the courthouse, basically saying, hey, all of these lawsuits are saying very similar things, so we should only have one lawsuit to decide these. And Ryan LLC was first, so that case should be decided in that decision, and the judges shouldn't try to be doing duplicative work all over the place. So what can we possibly expect in this Ryan case if one case in Texas could be the one that decides if the ban on non-competes is allowed to take effect in August, or if there's an injunction, meaning it's temporarily halted and delayed, or if it's permanently said, hey, this isn't illegal, and then there's appeals that would follow. But what's the possibility with this case? Now, I've talked about how there are a lot of very expensive attorneys that are representing Ryan in this challenge to the FTC non-compete ban. And the chief lawyer among those is Eugene Scalia, who is the son of the late Supreme Court Justice Scalia, and Eugene Scalia himself used to be the Secretary of Labor under former President Trump. But those are highly paid lawyers. What about the judge that's going to decide these? Well, the parties are always looking for sort of clues, and you can never know how a judge will decide. But the judge that's been assigned in this case is Judge Ada Brown. Now, Judge Brown was appointed to the bench in 2019 by then President Trump. So from the FTC's perspective, they may not be expecting a favorable ruling because she was appointed by President Trump, so you may expect her to be conservative and side with the business groups. And you never know how a judge will decide. She also is an alumna of Emory University School of Law, which is where I went, but I don't know her. But in the Ryan case, why a date is critical is that Ryan LLC filed its motion for expedited briefing. So they've asked the court, hey, this is really important, so can you please go ahead and make a decision very quickly? It's a shortened version of it. These are just all of the lawyers representing Ryan LLC. See, a lot. But so in it, they've laid out their proposed briefing schedule. Now, this is just Ryan LLC asking for a schedule. But they've asked that there be a decision from the court on whether the rule should be at least temporarily barred from taking effect, that decision comes by July 3rd, 2024. So they just filed that today. Now the FTC will issue its response and say whether it agrees with that timeline or asks for a different timeline, and then ultimately the court will have to decide what it wants its schedule to be. But Ryan LLC, who the FTC is saying, hey, this should be the court, the case that's going to decide the ban on non-competes. The plaintiff, at least Ryan, is asking that there be a decision on the ban on non-competes, whether it'll at least take effect or be halted temporarily by July 3rd. So we'll see what happens, but that's the latest update.